po ng Granada.
And offers a ₱1 million bounty to capture freed heinous crime convicts.
But maybe dead would be a better option. I will pay you smiling.
Meanwhile, the revised implementing rules and regulations seek to clarify provisions of the Good Conduct Law.
Papilials excluded, and you know all of this by now. Recidivists, habitual delinquents, escapees, and those charged with heinous crimes.
And addressing alleged corruption inside the BuCor. Live and exclusive, Justice Secretary Menardo Guevarra joins us in the program. Thank you for joining us. I'm Pinky Webb. A revised set of implementing rules and regulations of the Good Conduct Law, jointly released by the Justice and Interior and local government departments under the new guidelines. Heinous crime convicts cannot benefit from the Good Conduct system. The law giving prisoners time allowances because of their good behavior grabbed the spotlight after the aborted release of former Calauan mayor and rape slay convict Antonio Sanchez. The president's ultimatum for freed convicts to surrender, and how will the new BuCor chief reform bilibid? Let's go straight to the source of the story. We have him back, Justice Secretary Menardo Guevarra. Secretary, good to have you again. Maraming salamat po.
My pleasure, Pinky. Good morning
Perfect timing,
to you.
Huh?
And good morning to your televiewers.
So it's perfect timing, as I said, sir, because you just released the new implementing rules and regulations for the Good Conduct Law. Let's go straight to this, sir. Salient points. Disqualified. There are going to be convicts that are definitely disqualified from the Good Conduct Law, sir. Please name them.
All right. Under the law itself, which we simply clarified in the implementing rules and regulations, the revised one, the following are not covered by the GCTA law. Escapees, those who are recidivists, habitual delinquents, and those who have been convicted of heinous crimes. So in all of the benefits pertaining to good conduct, loyalty, special time allowance for teaching, studying, mentoring, and the like, they will not be included.
Pure and simple.
Because that's what the law said. And we simply clarified that in the revised implementing rules and regulations. We did not add anything at all.
Heinous crimes. Before we go to the meat of this, sir, what is under heinous crimes? Because I believe, sir, in 1993, heinous crimes has already been classified. What are the cases under heinous crimes, sir?
Yes, under the death penalty law, which was enacted in 1993, if I'm not mistaken, there were two classes of offenses that were classified there. One is those offenses where the death penalty shall be mandatorily imposed. And for that reason, we consider that as the heinous crimes being referred to. Mm-hmm. There is another class of offenses also mentioned in that law, but for which the penalty may be reclusion perpetua or death. So depending on the factual circumstances surrounding that particular offense. So murder, for example, may not necessarily be heinous. Mm-hmm. It could be, maybe reclusion perpetua would be the appropriate penalty at that time for murder, because maybe it was an act of vengeance, you know, yung family minasakir or something like that.
Gumante.
Act of vengeance, gumanti siya, so he committed murder. So would you consider that heinous? Probably not. All right. So, but yung first group of offenses definitely classified as heinous dahil mandatory death penalty ang ini-impose sa kanya. Like qualified bribery or drug trafficking, rape with homicide, kidnapping.
And serious illegal detention.
Yes. Kidnapping with ransom where the victim is a child or resulted in death or the victim was raped. So those are classified as heinous crimes. and the penalty imposed is death. Of course, we know that subsequently that law was repealed and the imposition of the death penalty was prohibited. But insofar as the classification of offenses is concerned, yes, that has not been repealed and we can go back to that.
So plain and simple, what was in the death penalty law back in 1993, classified as heinous crime, still serves as a heinous crimes classification now.
Yes.
Under the new IRR.
That is our view of the matter. And also, in addition to that, we are taking the Supreme Court's definition of heinous crime in very general terms, as the Supreme Court very clearly stated in the case of Echegaray. If you will remember, he was convicted of a heinous crime and he was subsequently executed by lethal injection. So in that decision of the Supreme Court described what a heinous crime is. So it's something that is vicious, intrinsically evil, outrageous to the common norms of decency and morality, so something like that. So an offense which may not be listed under the death penalty law, but would fall under that kind of description, could be considered heinous.
What is the difference, sir, of the IRR that you signed now compared to the IRR before?
I would say that the main difference is clarity, because the previous IRR did not make any clear specification as to who were excluded from the benefits of that law. So I guess that was somehow the reason why the application itself of the law, the actual implementation by the prison authorities, hewed along the line of pwede yan, hindi naman sila talaga echepuera, hindi naman sila talaga excluded, because Section 3 says convicted prisoners may avail of the following good conduct time allowances without repeating that exclusion found in Section 1 of the law.
So we can't really deal on this too much, sir, but what, of course, the Secretary is talking about is the law 10592, or the good conduct law, wherein there's supposed to be some sort of confusion between Section 1, which says that there are disqualifications to the law, as compared to Section 3 of this same law, which actually says that everyone...
All convicted prisoners...
Can.
Yes, can avail themselves.
I just need to ask this, no, sir, as a ordinary citizen. But if Section 1 already says they are disqualified, doesn't that hold true and above board? Sinabi na, unang-una sa Section 1, disqualified sila. Sa Section 3, sinabi all convicts. Pero sinabi naman sa Section 1, disqualified na sila. Sir, question, isn't that common sense? No.
Well, if you're asking me, yes. But it was interpreted in another way. So the mere fact that there are two or more interpretations merely shows that the law wasn't really very clear to begin with.
So if that is the case, sir, if it wasn't very clear, then it's the fault of the 15th Congress. Tama ho ba yun? Who passed the law in 2013? Not to pin the blame, because if you're saying na hindi masyadong malinaw yung batas, sino ho ba gumawa ng batas? Hindi ho ba ang Kongreso?
No comment.
I mean, really, it's not to say that, I know one of the authors is Congressman Rufus Rodriguez, who already said that first and foremost, nasa Section 1 na yan, hindi pwedeng recidivists, escapees, heinous crime convicts, but there was a confusion in Section 3. So prior to passing the law, they should have clarified this bago po pumunta sa IRR.
Exactly.
Okay. Now, next question. Should there be blame on Secretary then Laila de Lima, DOJ Secretary, and DILG Secretary Mar Rojas? Personally, sir.
Well, I wouldn't really put the blame on them in the sense that they willfully adopted a wrong interpretation. But maybe I would just say that perhaps if there was greater oversight over what's happening there at the BuCor, then probably this could have been discovered much earlier.
But then that holds true for you as well, sir.
That is very true.
Again, sir, if there was greater oversight, I could say the same thing about you and
Exactly.
Secretary Anyo, sir.
Exactly. We were totally unaware about this problem until it recently,
Hit the headlines
Right.
because of the Antonio Sanchez
exactly.
case.
Yes,
All right. To round this up, sir, meron ho pa kayang tanong after this IRR that you newly signed? Are there any possible questions that you see that may crop up?
Well, the position that we have taken that certain classes of PDLs or inmates are not covered. All right, some people believe that that was not, really the intention of the lawmakers. So they have this very radical interpretation, meaning, no, they're supposed to be covered likewise, no? Because Section 3 did not make any qualification. So that is the present position of the Department of Justice, but our interpretation cannot be considered the final interpretation of the law. Only the courts, more particularly the Supreme Court, will be in a position to make a categorical, definitive, and final interpretation of what the law actually meant.
Which brings me to my next question. Nasa mandate ho ba karapatan, or did you go overboard by clarifying the good conduct law?
No, because we were directed by the law itself to prepare the implementing rules and regulations. So
Even back in 2013?
even back in 2013, but of course we reviewed the IRR and found that there was a need to make certain clarifications there.
Because of the good conduct law, it again began because of the possible release of convicted rapist and murderer Antonio Sanchez. The question now is he still going to be qualified under the new IRR? We'll be taking a short break. We'll be right back. You're watching The Source on CNN Philippines. Our guest today, Justice Secretary Menardo Guevarra. During the break, we were talking about the Secretary being candid enough to say, this all started because of you. Because you said there is the possibility that Antonio Sanchez could be released. This sparked it all, sir. Hindi ho ba?
That is very true. Maybe that is a shock that the system needed para ma-review the whole thing from the beginning.
And again, as you were saying during the break, kung may pagkukulang man ang Department of Justice in 2013 and DILG, kayo din, Samuel, you were man enough to also say that, meron din kaming pagkukulang.
In a way, because everything has been running smoothly since 2014 and until this matter pertaining to Mayor Sanchez crop up, and all of a sudden, is that the case? So we had to review everything from the beginning and found out that, apparently this GCTA law has not been properly implemented. So that's where we started all over.
So the question is, can Mayor Sanchez still be released under the Good Conduct Law?
Under the Good Conduct Time Allowance Law enacted in 2013, of course, having been convicted of a heinous crime, he would be among those na excluded from the benefits of that law.
Excluded.
All right, excluded. So that means to say he would not be eligible for the additional and expanded good conduct time allowances provided for under that law. However, under the revised penal code na nahandyan na since 1930, meron ng long-standing provision on good conduct time allowance. So, mas maliit nga lang, no? Mga 5 days, a month, and so forth and so on. So, because siya naman ay convicted prior to 2013, prior to that law, and under the revised penal code, wala namang distinction. Regardless of the crime that you committed, meron kang entitlement to good conduct. So, meron din siyang na-earn.
Meron na.
Meron din siyang na-earn. Now, the only question is, did he properly earn? Did he correctly earn itong mga time credits na ito, even under the revised penal code? Kasi meron mga contentions na, how could that be good conduct kung nahulihan ka ng droga, kung meron kang violation ng mga jail prison regulations, no? So, although technically speaking, meron siyang entitlement to good conduct time allowances under the revised penal code. The question is, did he correctly or properly earn such time allowances?
Because even if, how I understand it is, may good conduct ngayon, pero meron din good conduct dati. Yung good conduct po kasi ngayon, mas mataas yung ibinibigay
Yes.
na palugit na
Correct.
pwede kang makalaya. Unlike before, Maliit lang.
Konti-konti lang
Oo.
siya eh.
However, ang question pa dun, sir, is meron siyang violation, so it may invalidate his good conduct under the revised penal code. Correct, sir?
Well, there is, of course, a provision that says na under the GCTA law that those allowances already given cannot be revoked anymore. All right, but the premise there is, of course, whether it was properly and validly given.
Got it, sir. So, siguro ang tanong na lang ng marami, makakalaya ho siya under the revised penal code, sabi niyo po, posible. Kung posible man, sir, could it happen in the next 10, 20, or 30 years?
That depends on the computation, no? And the review of any good conduct time allowances that were already granted to him. Kasi re-reviewin niya. First of all, nabigyan siya ng good conduct time allowances under the 2013 law. So definitely buburahin na yon, no? Because hindi siya na-entitled talaga ron eh. So how much time remains of his sentence, no? That is something that we have to find out. I cannot really say how many years more remain in his sentence because that is subject to computation. But I guess certainly not too soon. Not soon.
But could you qualify not soon as could it be in the next? Is it possible that in the next 5 years makalaya siya?
Yung actual na time served niya, if I'm not mistaken, is something like 25 years or 26 years already. Yung actual na
From
time that he had served, no?
From 1993 ata, sir.
I think 1995 yung decision.
Yung conviction.
Right. And he was actually incarcerated, I think, in 1997. Oo, kasi merong preventive na
Correct,
imprisonment. All right. Anyway.
More or less, sir.
He had served 26 years and the maximum na talagang life imprisonment is, commentarists say na hanggang 40 lang naman talaga yan. So assuming that everything is canceled or questioned or revoked because improperly or not validly granted to him, or he had nullified all of these good conduct time allowances because of some other acts that he committed, like halimbawa kung totoo na merong nakuhang droga sa kanya or something like that. Then, looking at the extreme side, he had served 26, 40 is the maximum, 14 years to go.
Kailangan, meron pang 14 years dun sa 40 years. A reaction, sir, from NUPL. Sabi po ni Ed Olalia, meron pong legal challenge dito sa IRR. It's a question I asked you a while ago, which I do understand that even in the 2013 law during the 15th Congress, it does specifically say here in Section 7 rather, that it's up to the DILG and the Department of Justice to really look into and to promulgate, or to create rather, the implementing rules and regulations. So it's something, again, you're doing, but it's almost as if are you interpreting the law, sir? Itong bagong IRR. So could this be challenged before any court?
We cannot really prevent anyone who might be minded to challenge that. In the same way that the IRR was challenged in 2014, because of a provision there that says prospective lang ang application ito. So somebody challenged that particular provision, and the Supreme Court sustained the argument na that can be applied retroactively. For the same reason, this new IRR that we came up with that very clearly specified who are not covered or who will not benefit from the benefits of this law, all right, may be challenged by those who take the view that that is not the correct interpretation of the law. All right, so it will be up to the Supreme Court to make that final determination of what the law really meant.
Copy, sir. 15-day deadline of the president for about, let's be clear, 1,914 heinous crime convicts were released, sir? Tama ho ba?
Well, that was the original number given, but we're reviewing that list and we'll come up with a cleaned up list by tomorrow, which is the deadline, para ma-weed out yung hindi dapat kasama dun sa listahan na yun.
More or less, ilan ho sila?
The original list was 1,900. So far, ang mga nag-turn themselves voluntarily in By today, baka nasa 700 plus. And we expect a lot more to turn themselves in tomorrow, the deadline, because otherwise they'll be considered fugitives already. So, but all of those who are supposed to turn themselves in are supposed to be those who were convicted of heinous crimes but were granted benefits under the GCTA law na sinasabi nga natin na improperly done kasi excluded sila from the benefit of that law.
Okay. The question is, sir, also, kung ikaw ay convict na pinalaya under the good conduct law, kasi kinumpute po whether correctly or incorrectly ang iyong sentensya at pinalaya ka, why would they want to go back? I mean, isn't it their right dahil pinalaya na ho sila? I guess what I'm trying to say is, could this be a case of possible double jeopardy? Kasi once freed, sabi nga nila, even Attorney Theodore Te was saying, it cannot be revoked. That answer after the break. You're watching The Source on CNN Philippines. Our guest today, Justice Secretary Menardo Guevarra. I was asking you, Secretary, kung ikaw, convict, good conduct time allowance ka, sabi ng BuCor, nakalaya ka na, tapos ngayon sinabi ni President, you have 15 days, otherwise you will be considered a fugitive. Why would anyone want to go back? Because pinalaya nyo na ako eh. Kung meron mang may kasalanan dito, sir, para sa akin, kayo, hindi yung convict. Yun sigurong pwedeng isipin ng nakalaya.
Well, that is possible. No? The inmate or the PDL who has already been released may think along that line. Na sabihin niya, oh, why fault me? Why should I go back? It was not I who computed the good conduct time allowances, etc., etc. But again, that's really beside the point. The point is, you were not supposed to benefit from this GCTA law because you committed a heinous crime. All right? And therefore, your release was improper, was premature. And therefore, you still have a remaining sentence to serve. And because of that, you have to go back. The good faith, your good faith or the good faith of the person who released you is immaterial. And that is the ruling of the Supreme Court in at least two cases. People versus Tan in 1967 and City Warden versus Estrella et al. In 2001. All right, so regardless of one's good faith, the fact remains that you have not completed the service of your sentence and you ought to return.
But the BuCor said, I completed my term with my good conduct allowance, sir. You see, I did not, the convict did not, these could be very different cases, sir.
Yes.
And there could have been corruption, which is a subject of an investigation, sir. But hindi naman po ako nagsabing at pinilit kayong palayain ako eh. Pinalaya po ako ng BuCor, hindi ho ba? And just in normal cases, the case of double jeopardy, sir, I guess I'm quite relating it to that. I don't know if I'm correct, though.
Okay. You know, BuCor is just an agency of the government. The state is not bound by the mistakes of its agents. All right, so that's the law. The BuCor is an agency of the government. It committed a mistake. The state itself cannot be bound by that mistake. There is no issue about double jeopardy.
No.
Because we are talking about the same penalty. We're not talking about being imprisoned for for the same offense, being imprisoned twice. No, because you are simply completing the same sentence that you have not completed. So there's no double jeopardy involved there.
Iba yun, ano?
Iba
Kasi
yun.
pag sinabing murder, pinalaya ka kahit na guilty ka, hindi ka na pwedeng kasuhan for the same murder. Yun ang kaso ng double jeopardy.
Exactly, that's double jeopardy. This one, it's the same penalty that you have not completed.
But the problem is, sir, the BuCor is the one tasked to compute this. And BuCor, Warden, and Bureau of Jail Management and Penology, sila po. Under the IRR, sir, kailangan ho ba ngayon ng go signal approval ng SOJ bago ho sila mapalaya?
In the revised IRR, we did not include anything of that sort because that is not provided in the law itself. All right, so we cannot add anything that the law did not authorize. So we can only do oversight, all right, but we cannot, you know, something like approve what you have already.
Would you rather have the SOJ approve convicts that could be released under the good conduct time?
The
good
actual
conduct law.
approval of good conduct time allowance is, is an operational day-to-day thing. So I guess it need not go up all the way to the Secretary of Justice. But I guess the actual release of the person might have to be made known to the Secretary of Justice.
Sir,
the actual release.
Yung actual release. Sir,
Yes.
kasi sinabi niyo the BuCor made a mistake. The mistake of the BuCor is not the mistake of the state. So the mistake of the BuCor is the mistake of Nicanor Faldon?
Well, not only he, but all those BuCor chiefs who interpreted the law that way.
Including him. So
Yes.
plain and simple, did they break the law? Are they liable?
Break the law, not in the sense that they willfully broke the law, as far as I'm concerned. Maybe they did it because that's how they understood how the law should be applied. So, but nonetheless, it's not, from my point of view, the proper way to do it. So I can't really make a judgment as to whether they violated the law, because they proceeded from an understanding that even these PDLs are included.
Are they liable? I understand what you're saying, sir, that they could have interpreted it the way they did, but are they liable? Is Nicanor Faldon liable and the rest?
Administratively, I would say that quite likely. Administratively.
Okay, there's a new BuCor chief, sir. Have you had a meeting with him? Nagkita na ho ba kayo? I know, bagong-bago lang po, sir. Former jail warden ng Parañaque and also former jail ng Manila.
I have not met him at all because he comes from another department, the Department of the Interior and Local Governments, na siya nagsusupervise sa BJMP.
Are you meeting him soon?
Maybe. Maybe because the BuCor is under the administrative supervision of the Department of Justice.
Last question before you go, sir. So magpo-proceed na ho ba yung good conduct law? Because it was halted.
Yes, we will start processing GCTAs because the IRR is already in place. But we're still finalizing the manual of operation. So that will spell out the nitty-gritty. But to the extent that we can already resume, because the guidelines are already there, except that we may just have to tweak the guidelines further. To the extent that we can already start computing, recomputing, and granting GCTAs, then we'll do.
So hindi na siya suspended, very clear?
No,
Okay, hindi
not
na.
anymore.
Thank you. Justice Secretary Menardo Guevarra, always a pleasure to have you, sir. And I hope to see you again.
My pleasure.
Maraming salamat. Thank you for joining us here on The Source. I'm Pinky Webb. You're watching CNN Philippines.